Good morning, Crime Talk aficionados. It is Saturday. We are live. A lot took place. Let's talk about it. Good morning, everyone. This is Scott Reisch of Crime Talk, and we are live on this Saturday morning. I'd like to thank everyone for tuning in and taking the time out of their busy day to join us. We truly appreciate that. This channel could not take place without you all, and we appreciate that immensely. For those who maybe are tuning in who have not joined us before, my name is Scott Reisch. I am a practicing attorney here in Colorado. Primarily, my practice is criminal defense work, and we started this channel to be able to help explain in greater detail criminal cases that are obviously going on, but maybe don't get the attention they deserve, and hopefully be able to provide some insight as it relates to the procedures that take place in a criminal case, a little behind-the-scene analysis, maybe a little insight that one who's been trying cases for 24-plus years, that we can give that to you and make hopefully people understand what's being done and why, so that, so hopefully to inform and hopefully to educate people, understand their rights, understand the process, and just be, more informed when it comes to these type of cases, because so many people just jump to conclusions, and it's very frustrating when that happens sometimes. And we want to make sure that people understand what's really happening, not what someone says and can't really back it up with the facts. We're all about the facts. We're all about being as accurate as possible. So, a couple of things today that I would like to touch upon. Yesterday we put up a video of the Chief Gallagher court-martial that's taking place in San Diego. And a lot of people think, oh, it's a court-martial. How is that really relevant to me? But this case got really interesting Thursday when the medic who was there with Chief Gallagher taking care of this prisoner of war, enemy combatant, whatever the term they would like to use, testified under oath that Chief Gallagher was not the one who killed this enemy combatant. It was, in fact, him, that he had suffocated him by basically putting his finger over the man's breathing tube that had been placed in there that he was there to provide medical treatment for. And the medic that was there, who was also Navy SEAL, I believe his name was Cook, testified that he felt sorry for this individual. He was probably going to die anyway, and he did not want him to be put in the hands of the Iraqi army because he had seen what the Iraqi army had done to these various fighters. And so this Chief Gallagher guy was, he's what you think of as Navy SEAL. He's a trained machine, and he does what he does. But he's very good at it. I mean, he had, I think, 8 tours in Afghanistan and Iraq. And, obviously that has effect on people. But what separates the professionals from the non-professionals is that you don't do what he's alleged to have done. And I don't know if he did it at all. He denies it. Some of the physical evidence doesn't match it, but it doesn't match the allegations that were made. And so it's going to be a really interesting case. But he was held in confinement. That was until President Trump and a lot of people got on board saying this Chief Gallagher should be pardoned if he is in fact convicted. And so it got interesting. And then definitely a little twist. And the significant thing was that this medic is the one who said that he's the one that killed the individual that somebody else is on murder trial for, testified under grant of immunity. So he cannot be prosecuted based upon that statement in court, because he's saying it's true. So that case is going to get really, really interesting. We have it, and it was also a big week in the United States Supreme Court. A lot of cases came down. The court is getting to the end of their session, and just a couple of cases that affect criminal law. Let me pull this up really quick, get the case name. And the reason I've been following this particular case is this has to do with felons and owning firearms. And I had a case that we were getting ready to go to trial on, and we were basically waiting to see what the Supreme Court ruled. And unfortunately, my client didn't want to wait, but it's significant. And in 99% of the cases that are what they refer to as felon in possession of firearms, it's not going to affect most of the cases. But this particular case, it was a gentleman by the name of Reisch versus United States, and it was a 7-2 opinion, and the Supreme Court said, of course you have to prove that somebody knew that they were not able to possess a firearm. That is huge for people that have been charged with this case, all right? Now, most states have felon in possession of firearm counts, statutes that would charge that. The feds have one as well, but frankly, it's much, much harsher. And that a felon cannot possess a firearm is actually in the Constitution. It's been somewhat expanded over the years under the Brady Handgun Act, whereby people, if you've been convicted of a domestic violence offense, that you cannot possess handguns, firearms, the whole gamut. I think it was originally intent was to be you couldn't possess handguns because that was the flavor of the month, and then it expanded to firearms. And this has been around for 25 plus years. And there were people I know in the military when this bill passed that had a domestic violence, and they couldn't possess a rifle, and so they had to be discharged from the military. But possession of firearm cases carry significant penalties. Most of them start, you're looking probably 3 to 10 years is the max, and then depending on the number of times, it can be really tricky. But the Supreme Court in a 7-2 decision in this particular case said that you have to know that you can't possess a firearm. And in this particular case, Mr. Reisch was a student. He was here on a visa. The visa expired, and then he went out and went shooting a firearm. Somebody sees it, somebody notifies somebody, because if you are not a citizen, you cannot possess a firearm. An illegal alien cannot possess a firearm. If you do that, you're punishable by this. And Mr. Reisch said, I didn't even know that I couldn't possess a firearm. Sorry, he was convicted, and he appealed to the United States Supreme Court, and the United States Supreme Court said, you're right. The United States attorney has to be able to prove that you knew that you were a prohibited person under the statute. He wasn't a felon. He was just a person prescribed that it was an illegal alien, therefore he could not possess the firearm. So that's significant. Why? Because it clarifies what everything we generally think about a criminal statute, in the sense that you have to prove a mental state. And the government is always trying to, for lack of a better term, make their job easier by not having to prove as much. And one of the things that always has to be proven, unless it's a traffic ticket for a strict liability offense, is that you knew what you were doing. You were aware of the conduct that you were engaging in. And that's significant, okay? And the significance of it is because you just can't go around saying you committed a crime. You should have known that it was a crime, and too bad for you. In this particular case, Mr. Reisch says, "Yeah, I'm here. I thought I was okay. We went to a shooting range." And I think it's interesting because if you go to, for example, Las Vegas all the time, they have these come shoot fully automatic weapons, and there's tourists in there all the time. I guess they're legally here on a visa, but they're Should they be shooting firearms? I don't know. It's kind of interesting, and I think there'll be ramifications. There'll certainly be more litigation about that. I know the United States attorneys are not going to like that, because when we filed our motion saying you had to prove that our particular client knew that he couldn't possess a firearm, they went ballistic because they couldn't, because they didn't have a whole lot of evidence about that. And so they fought that, and the judge was like, well, what does it matter? Just give them the instruction, and if the Supreme Court goes the way Mr. Reisch is saying that it should go, we're all good. And if they convict them, you've given it. You don't have to worry about having to redo the case. Now, the other case that came out from the United States Supreme Court this week is a death penalty case down in Mississippi. And I think that most people are generally appalled by the conduct of the prosecutor in this particular case. And the case is that of Mr. Curtis Flowers. In 2010, Curtis Flowers stood trial for the 1996 murders of 4 people in a Mississippi furniture store. The local district attorney by the name of Doug Evans, who's white, struck 5 of the 6 potential black jurors in the jury pool, resulting in a jury with just 1 black member. Flowers was convicted and sentenced to death. Today, the Supreme Court threw out Flowers' convictions, with 7 justices agreeing that the jury selection in his case violated the Constitution. The opinion was written by Judge Kavanaugh, most recent addition to the United States Supreme Court, and it was joined by Chief Justice Roberts, Ruth Bader Ginsburg, Breyer, Alito, Sotomayor, and Kagan. And they depict Flowers' case as one that broke no new legal ground. Instead, the court characterized the ruling as a fairly straightforward application of the 1986 ruling in Batson v. Kentucky, holding that prosecutors cannot discriminate based on race when using their peremptory challenges, which allow them to remove jurors without providing a reason as to why the person should be discharged. You have to have a neutral reason for that. So let's talk about that really quick. When a trial starts, obviously the first process is jury selection, and you have to have jurors that are qualified. Every state has a list of what makes a juror a qualified juror. But then you have to find out if they are going to be a fair and impartial juror. Are they going to be able to give a fair hearing to the evidence in the case and not make prejudgments? So basically, are you willing to listen to all the evidence, reserve judgment until all the evidence is done in the case, and then follow the court's instructions, applying the facts to the law given, and applying the law even if you really don't like it or understand it? In jury selection, though, there are challenges for cause. If somebody says, you know what, I just can't be fair, I've been the victim of the same type of crime, I don't think you want me on your jury, they are excused for cause. If they moved out of the jurisdiction, they're removed for cause. If there's something that they're so busy, they're so distracted, they can't be excused or just can't focus, you can excuse them for cause. If they have medical issues, they're caring for someone that's disabled, they're excused for cause. Then, when that is over, each side, the prosecution and the defense, gets what they call peremptory challenges. You can get rid of jurors for any reason that you like. You don't have to explain it. It's just, I don't like them. I don't get a warm, fuzzy feeling when I talk to them. And frankly, what really happens is the prosecution tries to get rid of jurors that they think will lean towards the defense. The defense tries to get rid of the jurors that the defense believes will lean towards the prosecution. And those are discovered in voir dire, which is what's called for the attorneys where they actually ask the questions. You don't really hear about this often in the news, but I'm telling you as a trial attorney, this is the most important part of any case. The case is usually won or lost there. And so you try to talk to everybody, but oftentimes your time is limited. In death penalty cases, you have a lot more time to talk to everybody. But like for Mr. Flowers' case. However, in the Batson case, the Supreme Court said you can't get rid of a particular juror based upon race just because, for example, they're African Americans. You can't do that. And so, just because you strike let's say you have a Hispanic defendant and you strike a Hispanic juror, that in and of itself is probably not enough to seat the juror with a Batson objection. Now, if the prosecution gets rid of 3 Hispanic jurors and you have a Hispanic defendant, you're going to say, Your Honor, may we approach? And we'd ask that the juror not be excused until we've made our record. And then you go up and you make a Batson challenge and say, Your Honor, my client is of a particular nationality. The district attorney has now excused 3 people of the same nationality. We're making a Batson challenge. At that time, the district attorney would then only have to provide a race-neutral explanation for the excusal of that particular juror. And they can say, well, Your Honor, based upon their statements, they said that they would have a hard time believing the prosecution because their brother was prosecuted by the case. Doesn't rise to the level of cause, but for whatever reason, the DA would do that. And that would be their answer. They come up with something that's neutrally a neutral explanation, nothing to have to do with race at all. And the judge would say, fine. If the judge thought that it was being used that the district attorney was trying to get rid of potential jurors in violation of Batson, then the judge would sit the juror back down and say, fine, you're staying as a juror. Well, in this case in Kentucky, this particular DA had tried the case 3 previous times, and in every case struck 36 black prospective jurors. I'm sorry, I misspoke, said 3 previous trials. This gentleman, Mr. Flowers, was tried 4 times. Okay? The first 4 trials, let's see. The first 4 trials, the court observed that the numbers speak loudly. In the first 4 trials, Evans, the district attorney, tried to strike all 36 black prospective jurors. The state's relentless, determined effort, Kavanaugh concluded, to rid the jury of black individuals strongly suggests that the state wanted to try Flowers before a jury with a few black jurors as possible, and ideally before an all-white jury. Such a history, Justice Kavanaugh stressed, cannot be ignored when considering Evans' intent going into Flowers' 6th trial. At Flowers' 6th trial, Kavanaugh continued, Evans struck 5 of the 6 prospective jurors. Kavanaugh acknowledged that Evans allowed 1 black juror to sit on Flowers' jury, but he noted that in a 2005 case, Supreme Court suggested that a Texas prosecutor might have accepted a black juror to camouflage a general opposition to seating black jurors. Justice Kavanaugh said the overall record of this case suggests that the same tactic may have been employed here, creating more evidence that Evans intended to discriminate against black jurors. And when I heard the facts of this case, that it was going up to the United States Supreme Court, I thought this is a no-brainer. Obviously, the Supreme Court agreed in a 7-2 opinion that you just simply can't do that. So now Mr. Flowers, who's had 6 trials, may have a 7th, and hopefully this district attorney will not try the case. But as a good district attorney once told me, if he has a good case and he has a strong case, he'll take the first 12 jurors you give me. Let's go do this. And if this case is so overwhelmingly strong, which apparently the case against Mr. Flowers is not potentially, and I'm not going to admit that I know any of those particular details of the case, but apparently there are issues, and so it seems as though Mr. Flowers may be going home. If the case is reprosecuted, though, Mr. Evans, the district attorney, may think about having somebody else do it, and he should not play games on jury selection. I'm surprised that a judge would allow that to take place, but you never know what the judges are going to do. All right, so here we are. Oh, one last update on cases that we've been covered. The Jussie Smollett case. Big, huge development in the Jussie Smollett case. Friday, the judge is appointing a special prosecutor. And for those who aren't familiar with the Jussie Smollett case, Jussie Smollett was an actor on the Fox program Empire, and for whatever reason, he decided to fake an attack saying that he was assaulted and that it was racially based. He went to the police. Ultimately, it turns out that it was not true. He fabricated the whole thing. He had paid a couple of friends or somehow his fitness coaches to do this, and ultimately he's charged by the Chicago Police Department with some 16 felony counts. The district attorney on the case, who had had contact with Smollett's family, says that she, quote, recused herself, but had her right-hand person, her deputy take care of it, and they offered him basically a deferred prosecution, do some community service, forfeit his $10,000 bond that he had posted, and the case was closed. There was a ton of outrage by lots of people, from the police department to district attorney councils everywhere to everyday citizens who were just simply outraged that they would probably not get this same benefit of the bargain that Jussie Smollett received because of his fame and status. So a former judge filed a case under some Illinois law that said they could look into it. The judge was basically somewhat shocked at the proceedings because the district attorney can't recuse herself but allow her right-hand man to do it. So he said there was not a conflict, but the way she went about it basically made it smell. And so a special prosecutor is going to look into the case. Mr. Smollett can be potentially recharged, and the district attorney, Ms. Clark, could potentially be charged as well if there was anything weird or hinky going on with her contact with people related to the Smollett case. And so I don't think Jussie Smollett is happy with that decision. He shouldn't be. He should be concerned, because I don't think he's going to get the same benefit of that bargain second time around. So we'll be watching that. So I know that was kind of a long introduction, but just a couple. It's been a very busy week with cases that we've been following going on. The Supreme Court's been really, really busy with cases that affect, in the criminal defense world, significant case law. And we won't get into the other cases that they talked about because they're not necessarily crime-based, but certainly interesting in that regard as well. But we won't go there. Smollett case is obviously a big deal, and so we'll just leave it at that. So try to look at some of these comments here and see what people would like to know. Sometimes these go by really fast, and if people want to do that super chat, they certainly may, but it certainly highlights it, but that's all right. Let me. Is there a cold case unit in Colorado? Okay. Question. Somebody asked, is there a cold case unit in Colorado? Yes. There are many. Most district attorneys' offices have a cold case unit, the larger offices. I believe here in Colorado, Carbier investigation helps the smaller jurisdictions if there's a cold case. But for example, in Denver, they have a cold case unit. Most of them now are going back and using DNA evidence to see if they can't find the correct individuals. Denver was really at the forefront of a cold case unit We had a former district attorney here. He's been out of office. He was term limited, but by a gentleman by the name of Mitch Morrissey. And he was a very, very good prosecutor. And he was really one of the first experts when it came to DNA, because although DNA comes in now, it was not scientifically accepted many, many years ago, probably 25 years ago. I remember doing a case and they had to prove that it was scientific reliable. And it was really cutting edge technology, even though now, today, it is absolutely assuming that the DNA evidence is collected properly. There's not any sort of contamination issues. If there are nothing that would give pause to the testing, it's usually generally accepted. But the interesting thing now is the statistical analysis that has developed, or the lack thereof. When a DNA analysis would come back, we'd say, oh, the odds of this being some person other than the defendant are 1 in 650 quadrillion. I mean, that's a lot of zeros behind it. I think it's like 15 or something. But then if you have a statistician run it, and then it depends on the size of their DNA database. And everyone's heard the quote, I'm sure, there's lies, damn lies, and then there's statistics. It depends on how they're going to use their statistics. And so that's really the battle, because depending on the size of the DNA sample, the class of people that they could test from depends upon it. As the samples get much larger that they can test, possibly obtain a match from, the more reliable it will be. But DNA is here to stay. It's only going to get better. And frankly, I love DNA. DNA has probably cleared more clients of mine by them simply finding out wasn't your guy. Usually when there's been an investigation and a trial, if it's there, a lot of times, from a defense perspective, it helps, because you can say, how to get there. Yes, my DNA can be left or transferred from where I sit, where I touch. But for the most part, if it's at a crime scene, you're going to have to be able to try to explain it. And if you can't, the defendant usually has problems unless he lived there or had a reason to be at a residence or something along those lines. But overall, I think it does more good. There's obviously been people that have ever been exonerated because of DNA. It's truly good. Let's see here. I have a question. Scott, do you ever take out-of-state cases? Yes, we do. Just finished a case in South Carolina for a gentleman that had a interference with aircrew charge. And I think I've mentioned this before. I have a home in South Carolina. I love South Carolina. I would love to live in South Carolina someday, maybe when I retire, which is still a ways away. Finishing up a case in New Mexico, big racketeering case that we were on down there. It's getting wrapped up. Wyoming, South Dakota, you name it. Most jurisdictions require someone from out of state to have local counsel, and you can be admitted what they call pro hoc vice. And basically, you're allowed to be permitted to handle that case with the assistance of local counsel. I've done that before for attorneys that have come into town. It usually works out well. My experience is on my end. I usually wind up doing more work than necessary. Question: any updates on the Patrick Frazee case? Nothing from our last video where we talked about the Frazee matter a couple of weeks. No, I guess it was this week, wasn't it? Maybe last week. Yeah. The judge had authorized the defense or the prosecution to do the consumptive testing of a fragment of what they believe to be a tooth to see if is in fact that of Kelsey Barrett. Haven't seen or heard anything regarding any of those results. I'm always curious sometimes when they're not sure if they think it's a fragment of tooth or something along those lines, and they haven't been able to test it yet. It's always sometimes I had a lady once where the police were absolutely positive that she had this huge amount of crystal methamphetamine. They arrested her, they charged her, and they went and they then tested it because they have to test it to see if, to prove it's actually what they think it is. And it turned out to be a crystal, all right, like the rock. So sometimes they're not exactly sure, and that's why they do the scientific testing. So we'll see about that. Let's see here. Oh, the parents brace. Oh, yes. The question about the parents baseball brawl there in Colorado. I think they made national news. Apparently there's a kids baseball game. The umpire is some 13 years old. Parents get upset with the call, and next thing you know, a fight ensues, and it's on TV. And there you go. I have not heard if charges have actually been filed. They should be. That is just absolutely atrocious, in my opinion. These are the parents. They're supposed to be role models and examples for these children, and they're out there assaulting each other. And I can tell you, parents and their kids' sports can be one of the most can be one of the greatest things to ever take place, or it can be one of the worst things that can ever take place. And I mean that as my son used to play baseball, competitive baseball, and it was ridiculous. These 10-year-old kids are playing 80 games a year, which is like half the season for a Major League Baseball team. They play 162 in Major League Baseball. Every parent is out there living vicariously through their kid, thinking they're all going to, go off to the major league someday. The coaches are even the worst, and they always put their kid on second base or their pitcher or first base. And, they eat, sleep, drink this stuff. And it's like, dude, we're talking 10-year-old kids. Like, let's do it right. My son was like so burnt out from 3 years of playing competitive baseball. He's like, I'm done. And then he went on to play golf, and it was a great experience. But these parents were so involved, and my son's coach, I believe, had restraining orders with other coaches because they would get into it and they would fight and threaten. It's just disgusting. I cannot believe that those parents did that. I mean, every one of them should be banned from any of those games, and obviously shouldn't be allowed any type of coaching. And frankly, the coaches, if they can't control them, it's just disgusting. We're talking, it's baseball, people. It's called youth baseball. It's to learn the lessons of life. And guess what? Sometimes in life, bad calls are made, but it doesn't mean you go beat somebody up or you have your parents come and beat somebody up. That is just absolutely ridiculous. I can't believe that happened at all. All right, let's see here. Any questions? Let's see here. Yeah. Pray someone would come for you. Yeah. Make these parents look mild. Let's see here. Someone from Australia tuning in. Suze I-27. Thank you for tuning in. I'm surprised people, if people have a question about any cases that they'd like to ask a question about, or any procedural issues related to a case, now is your time. Please don't hesitate to ask it. We'll try to ask it in, hopefully to everybody's satisfaction, so that it's informative and everybody gets something out of it. I'm going to pull something up here. The cases that, like I said, we have been following. Tried to give you a quick recap on those today. I'm sorry, just completely froze there in my mind. the Delphi, I couldn't think of the name. The Delphi murders. Those are, I was looking at some information last night, trying to prepare for this, and we were hoping that something would have come from the police releasing more information, kind of hoping that there was an issue that basically kind of try to force somebody out, flush their suspect out, saying they probably know him, they know he goes by the scene every day, etc., but they just don't have enough to go, get the guy. So that is the Delphi cases are really interesting. I hope there's going to be a break in that soon. I mean, those two little girls, they deserve justice, no doubt. Let's see, Cheryl, Scott, are you back flying? Well, kind of. I love flying. I love having my plane. I've never had this many issues with an airplane in my life. As you may recall, back in March, I told you we were heading out. It was a Sunday night. We were heading back for, I think, week 2 of a 3-week trial, and we were climbing out, and all of a sudden the engine just lost power. My gauges and my instruments said that the engine was still running, but I didn't have any manifold pressure, so I immediately declared it an emergency. My associate in the co-pilot seat looked a little tense. I wasn't particularly worried. I was just flying it. My biggest concern was this just came out of annual. Why is it not fixed? And how much is this going to cost? And so went back in. They replaced some parts. Was getting ready to go flying, I guess 2 weeks ago on a Sunday to go be a test pilot to make sure everything was good to go. And things didn't even check out on the ground. So back in the mechanic, he fixes what he thinks he's going to fix, and then he finds another problem. And so here we go. It's been very frustrating. Fortunately, I've had some friends who have given me a friends and family discount when I had to be someplace for court. And, if it takes me an hour to fly there versus 7 hours of driving, it's just good for everybody. It's just, it's better, but I love flying. I love it because you can only think about flying, and that's all you can do. You can't think about everything else. So it takes your mind off of work. I love it. Let's see here. Blonde PT, your predictions on what the judge will do with the new witness confession in the Navy SEAL case. I don't know what is typically done in a situation like that. Oh, I didn't see that. Hold on one second. So my prediction. So going back to the Chief Gallagher case, a witness testified that the defendant, Chief Gallagher, did not kill the prisoner, but that he, in fact, had done that. That's significant. Usually that's the kind of case where basically you take a break and the DA decides what the heck to do. Or in this case, military counsel, the prosecutor. I would think this weekend he is deciding how and if this case can go forward. When somebody else points to themselves saying, I'm the one that committed the crime, that is not good for the prosecutor, unless you're proceeding on some sort of a complicity theory. And I don't believe that that's the case. They're saying that this Chief Gallagher is the one that did it. So not good for him. Now, the judge at the end of the case in chief will receive what they call for a motion of judgment of acquittal by the defense. Usually, a motion for judgment of acquittal is only granted if the prosecution forgot to present some evidence to each element of the crime that they have to prove. Here, identity is obviously an issue, that they have to prove identity. They have to prove that Chief Gallagher did it, not someone who looked like him, not someone nearby him, not someone using his identity, but him. And so somebody else comes in and says, I did it. Obviously, that raises significant doubts as it relates to Chief Gallagher's guilt as that crime charged. Can the prosecutor is the one that is the only one that can dismiss the case now. A motion for judgment of acquittal, the court could do that. However, the legal standard is, just like in the military court, as it is in just about any state or federal court, that the evidence has to be viewed in the light most favorable to the prosecution, drawing all inferences in the favor of the prosecution. The judge will say, although I believe there's doubts, it's questionable testimony, that it is a question for the jury to decide, and that the judge will not substitute his judgment for the jury. I've heard that a million times. I've heard judges, say that, and juries come back not guilty. I've heard that before, and the jury finds him guilty. So it just depends on the evidence, depends on who the jury is. In this particular case, a military jury, there were 5 Marines and 2 sailors. The jury is usually made up of all officers, but if you're an enlisted person, you can have 1/3 enlisted, and they have to be of equal or greater rank. And so, they have a very senior jury. You have a chief petty officer 20 years in. You're going to have some senior enlisted people in that case. It'd be very interesting to see where they come down. I'm assuming the defense will put up what they refer to as good military character defense. There's an instruction in that case in the Uniform Code of Military Justice that can be given. And it basically says, you're such a good soldier, sailor, Marine, airman, etc., and the defense has raised good military character. It says that in and of itself will be enough to raise reasonable doubt, which is basically you're a great Navy SEAL in this particular case, and we're going to give you a pass for whatever you did simply because of your good military character, and basically everybody's entitled to one bad day. However, that is it can cut both ways, because once you open up character evidence, and most of the times character evidence is not admissible in court, you open up a can of worms, because then you get to test the basis of that character evidence, the prosecution does of the defendant, and you get to bring in things that oftentimes you cannot, you don't want to bring in. All right, Jennifer, sorry I missed your question here, and we're back to it. It says, how hard is it to win a case with only circumstantial evidence? It's not necessarily that hard. Prosecutors win cases on, quote, circumstantial evidence all the time. There's a jury instructions that's given that says direct and circumstantial evidence are the same. Okay? Direct evidence is if I look out the window and it's snowing, I say the evidence is that I looked out the window and there's snow on the ground. It's snowing because I saw it. Circumstantial evidence is simply I went to bed and there was no snow on the ground. I woke up the following morning and there's snow on the ground, but it's not snowing now. Obviously, it snowed overnight. I didn't see it. That is circumstantial evidence, though, that it snowed. Does it? Because it's on the ground, correct? It's viewed the same way as any other evidence. People can take it, jurors can take it for what it's worth. So when people say there's circumstantial evidence, that just means that they didn't have somebody looking right at it when it took place. So cases are won all the time on circumstantial evidence, and like I said, the law is that it's viewed the same as direct evidence. The jurors are the ones that decide to give it what weight, if any, it deserves in their deliberations. Let's see here. Cindy Sue, Scott, not playing golf. Nope, not today. Haven't played in a while. I spoke with my son this morning, though, and he was going to go play some golf, which is very nice. He's got a very good deal down there in the great state of Mississippi, serving our country as a pilot in the United States Air Force. God bless him. I'm totally living vicariously through him. Let's see here. Scott, what is the government doing about all the deaths in the Dominican Republic? Can they go test the bodies? And do U.S. investigators? Too many coincidences. Yeah, that whole thing in the Dominican Republic is very odd. I mean, I don't know how many people have died in the past that went to the Dominican Republic. Obviously, there's a couple of circumstances that seem very odd. I saw something about a lady that was actually attacked quite brutally by hotel employees. I mean, that's a crime. I guess I'm just not sure is it any greater people that are dying in the Dominican Republic. I don't know. I've never been to the Dominican Republic, but I've always heard it was a little sketchy. So that's one of the reasons why I probably have not gone. Let's see here. Quick question. Chris Watts was convicted and sentenced twice for killing each kid, which is not permitted. Can you explain how the DA got away with that? No, he didn't get. He pled guilty to one count for his wife and the children, and then one count because Colorado has a fetal statute. It's not murder, but pled guilty to that. So no, that's not correct. Scott, I think jurors have biased opinions. Of course they do. Everybody goes into jury situations with biases. It's simply that's the world. We all have biases. The question is this going to affect your ability to be fair and impartial as a juror? We don't expect jurors to come in a vacuum and turn off all their realities and experiences and life experiences that go on in the world. That's just reality. But the question is, does that bias so great that it's going to result in an unfair trial to either side? All right, it's not just to the defense, which a lot of people think about, but the prosecution is entitled to a fair trial as well. So if you have a juror that hates the prosecution, he shouldn't be there. All right, and I will be the first one to say, if this guy says he can't be fair to the prosecution, get rid of him. All right, because I would lack any credibility if I said keep him. But don't get rid of the people that say they can't. When the prosecution says they can't be fair to the defense, I mean, just they can't. It's just fair. So yes, they have that. Let's see here. Oh my God, it's wild. Isn't that funny? We've done it so many times now. We're afraid. It's interesting. I'm not sure what that means. Let's see here. Let's go. I'm trying to look at this here really quick. Okay, somebody. Let's see here. My son's a pilot, Air Force. He went to the academy. My son went to the Air Force Academy too. He graduated class of '96. No, I'm 2016. I'm sorry, '96. Jeez, 2016. Yep. Yeah, my son's a pilot in the Air Force. He went to the Air Force Academy, Colorado. I'm proud of them. Yes, I am too. God bless your son. Good stuff. Air Force Academy is a great school. All the military academies are a great school. It's an amazing, amazing education. And the kids there, we used to have my son's kids come home over the weekends. And the kids that go to the military academy, they truly are some of the best of the best. That kind of restores your faith in mankind, and it makes you think that we will be in good hands in the future. I don't know what the statistics are, but for the Air Force Academy, they had, these are top tier kids that could go to any school they wanted to, but they chose to serve in the military. They own an obligation when they get done with their education. The education's valued about $500,000. They have some of the best professors. The classes, it's so rigorous. Their day starts early in the morning, it doesn't end late at night, and even when the lights are out, they're still studying and working. My son said it was the hardest experience of his life, but worth every minute of it. As they say, it's a terrible place to be at when you're a student, but it's a good place to be from once you've graduated. It's very, very good. I was never smart enough to go to anywhere, but I've been telling my son from a young age, I think when he was about 2, that he was probably going to go to the Naval Academy, given the fact that his grandfather is a retired admiral. So I pushed that, and then the Air Force came along, and I was like, of course you got to go to the Air Force Academy. It's close by, so I can see every week. So let's see here. Let's see here. Let's see. Okay, here, Chris was convicted of first-degree murder for Bella. Life as consecutive sentence, plus first-degree murder for Bella has a different theory. Life, concurrent sentence, same thing. And he pled guilty to first-degree murder. They're all consecutive life sentences. That's it. They can charge them in the alternative, but when they pled guilty, that's it. But they didn't merge. They weren't concurrent at all. They're all consecutive. They have to be by statute. All right, let's see if we got one more thing. Let's see. Miss Murder Australia. How's the Senate 68 bill going for doxing swatting? I am going to, sorry you spent $2 on that, but I am not sure of the status on Senate 68 bill for doxing swatting. Let's.
Why is Chris Watson protected, but Jeffrey Dahmer wasn't?
Question: why was Chris Watson protected custody and Dahmer not? Dahmer probably didn't ask for it. At a certain point, if you're in protective custody, it's, the people going into protective custody are people that are in fear for their life. They're in protective custody because they've asked to be there. Okay, you have to ask for it. But eventually you're going to want to come out because you can sit in your cell for 23 hours a day, have limited contact with other people, basically people in the same situation for you. But at a certain point, they're going to say, hey, you got to go back to the yard. And at some point, someone's going to want to see somebody's paperwork to see what you are in for. And if you can't produce the paperwork, what you're in for, that's going to be a problem. And everybody knows what happened to Dahmer, right? He's dead. They don't like high-profile people. There is a hierarchy in prison. It's very primitive, primalistic. It may not be the smartest guy in charge. It may be the guy that can kick somebody's ass the best. Strength matters in prison. The hierarchy is that if you have sexually assaulted children, you're going to have a very miserable life. If they don't kill you, they're going to make life miserable for you. If you are a rapist, life is not going to be good for you. People, it's just not accepted. Even prison, which is always ironic because they sexually assault prisoners in there all the time. But there's a hierarchy of that. And obviously, if you kill women and children, you're the bottom. You're the scum of the bottom. I assure you, he's in protective custody. It is not a good life, okay? It is not a comfortable life. He's safe, but eventually he'll get out. Eventually he'll walk down a hallway somewhere. And, if people even they're protected, if somebody wants to get him, they'll get him. If the guards allow it, turn their back, send them somewhere, it could all be, over just like that. There simply are not, there's just simply, it's not a good place to be. Let's see. How fast will we see a death for Tim Jones? I'd have to look. I think they set a sentencing date. I think he's going to get death. But they have to formally impose it, and then the appeals begin. And I'm not going to say that I know what the process is or how long it'll take, but my guess is even if unless he says, I waive any appeals, like just says, bring it on. Remember, like Timothy McVeigh, after he did the bombing of the Oklahoma City bombing building, he was found to get the death penalty, and he said, I don't want to waive any appeal, or I waive all my appeals, bring it on. Even then, I think it was still a year or two from that date. Or I guess he started to appeal because I knew the attorney, and then they found a box of documents. And in fact, that Judge Mage, one of the best judges in the country, just recently passed away at 96 years old, and he was still practicing or still on the bench and keeping a pretty full docket. So to answer that question, I don't know. It's not going to take. It's going to take years. It's going to take decades. Probably 2 is my guess. All right. Let's see. We're just about up. We're going to stop here. It's at 12 o'clock. We're right upon it. I guess we'll see if there's any last minute questions that we can answer.
Did you know DA Christopher John Coolish? I guess
Oh, yeah. Question. I know Attorney Coolish, the gentleman that passed away climbing Mount Everest. No, I did not. The name sounded vaguely familiar, but I thought he practiced civil law. So yes, I did not know them. Question: how many times can a DA retry somebody if the jury splits in a murder case? The technical term is a hung jury, and the district attorney can retry the case as many times as possible. At a certain point, though, they are simply going to say it's just not worth it to keep going on. Quick, Cheryl, glad you got your coffee mug. See, I follow through, people. My word, I follow through. So if a jury hangs, whether it's 11-1 or 1-11, it doesn't. The DAs have to take a look at it. Most DAs are going to say that okay, we had a wild jury. I once had a case. We had a 5 co-defendant case. I won't get into the facts of it, but the first trial was supposed to take 2 weeks. It took 4. After 4-week trial, it hung. We do it again. It hung. We do it again. It hung. 3. So the question was, okay, we found perhaps 3 jurors that perhaps didn't hear and see all evidence that everybody else did. The question would be, would there be a 4th? And ultimately, in that 4th trial, the district attorney made a offer that no one could refuse. Clients were happy because they no longer had to deal with the case, and basically they were going to go home, and the DA got what he wanted, which was a conviction. And even though the job of a DA is to do justice, not just to get convictions. So I want to thank everybody for tuning in today. We will have new content out this week, and depending on the schedule, we'll try to go live again next Saturday, but I won't promise that. But that is the intent. Please, if you like the channel and you haven't subscribed, please do so. If you like our videos, please like them. Hit that little bell so that you receive notification. We do truly, truly appreciate everyone that tunes in, everyone that watches our videos, that likes and leaves a comment. We do appreciate that. And although, some of the things people say on these comments are bizarre. I am not out hawking mugs. All right, people? A friend had one of these made, and then somebody said, hey, can I get one of those? So they had it made. And then other people started asking for a mug. I have a small collection of mugs now, and we've given them away. The ones that I've purchased on my own, we've given them away. If you want to buy a mug, you can go buy a mug at Teespring and go to my page, and they'll ship you a mug. It takes you a couple of days, maybe a week, I think. And that's it. If you want a mug, have a mug. Am I going to quit my day job because I sell a mug or two? No, ladies and gentlemen. It's not for me. It's people that have asked to have a mug. Who wouldn't want to have this mug? This is a great mug. It's got the CrimeTalk little thumbprint there. Let's talk about it. If you like a mug, buy a mug. If you don't like the mug, you don't have to buy a mug. I'm not hawking anything. I'm not begging you to go buy my merchandise, so to speak. I only did it because somebody gave it to me and said we could have, and I said, well, if we can make it available to everybody else and I don't have to deal with it, let's do that. So that's it. So thank you for watching. And if you get a mug, thanks. It helps keep the power on here, I guess, for a very small percentage of it. But that's not why we got into this. It's not why we started the channel. We did it to inform, educate, and hopefully that is what we're doing, and hopefully you all agree. It was not the intent to sell merchandise, I assure you of that. So have a great day, enjoy your weekend, and we'll see you Monday with some new content. Thank you very much.